One courtroom, multiple lives hanging in the balance. From probation violations and shocking admissions to desperate second chances and serious felony charges, today's docket is packed with tension, tough decisions, and moments that could change these defendants forever. But the real question is, who's walking out with another opportunity, and who's one mistake away from losing everything?
Good morning, sir. You are Joshua Barlow.
Yes, ma'am.
This is cause number 18-26688. Mr. Barlow is on probation for possession of a controlled substance. A motion has been filed. What is the announcement?
Judge, we did a short reset on this one because we had a court date out in Harris County. Was in hopes that they would go ahead and dismiss that one then, but it looks like we will be moved to the trial docket. I believe they're going to try to subpoena the complainant over there. And so I don't know how long it's going to be or when.
But it's
That's
understanding for Mr. Lewis, and I have no reason to doubt that based on my knowledge of that offense, Mr. Barlow, et cetera, that their subpoena of her will be against her will. And I don't intend to proceed on that with the court's permission in the motion under those set of circumstances, Judge, if that makes sense.
Right. And so do we, what are the other allegations? What's the?
If we could maybe at this juncture, knowing that, if we could just abandon or bypass those at this moment and have them enter pleas of true or not true just to the administrative violations, maybe get an update, see if there is for some reason any change in that before I formally abandon it. But it is my intention and it is my understanding based on the facts of that case that there's a subpoena of her, and correct me if I'm wrong, it's probably against her will.
Right.
Over there, I mean, are we going to wait 3 years for him to go to misdemeanor trial?
No, we're doing it here. And if you want to get her here or try, that's one thing. If not, we're not waiting on that. So let's go ahead and go through the motion and get pleas of true or not true. And I will, it looks like skip number 1, number 2. Just those 2. It looks like it have to do with that other case. Okay. Mr. Barlow, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And will he waive the formal reading of the motion?
You would, yeah.
Get this done real quick. Hold on. Sorry. All right, Mr. Barlow, in cause number 17-26688, I have a motion to revoke your community supervision. Shows that you were placed on probation September 18th of 2017 for the offense of possession of a controlled substance, a second-degree felony. Now, it was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 3 alleges that you failed to remain in Jefferson County as ordered and that you were in Harris County, Texas, November 8th of 2025, and that was without permission of Jefferson County probation. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 4 alleges that you failed to immediately report to the Community Supervision Department an up-to-date physical address. And is that true or not true?
That
you didn't tell them a new address
It's not true.
where you were living. Okay. Count 5 alleges that you failed to immediately report to the probation department your arrest from November 8th of 2025. Is that true or not true?
True.
Count 6 alleges that you provided a urine sample March 4th of 2025 and April 8th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Can you say what?
Marijuana.
Oh, true.
Count 7 alleges that you're behind in your court-assessed fees as of November 19th of 2025 in the amount of $4,734. And is that true or not true?
True.
Did you enter your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for a sentencing hearing. We'll get an updated pre-sentence report, find out anything else about those cases in Harris County, and then we'll come back at that date for sentencing. Are you currently wearing a drug patch? Are you ordered to wear a drug patch? Before you leave today, I want you to have a seat in the jury box. We're going to get a drug test this morning. All right, have a seat. Actually, come over here first and get a thumbprint, and then have a seat for a drug test.
That's unagreed.
Unagreed, yes, ma'am. Doesn't matter if you're going to do something in court or not, but anywhere you're going, you need to pay attention to what's on your clothes.
I got you.
You understand? Will he waive the formal reading of the indictment?
Well, Your Honor.
Mr. Chandler, in cause number 25 DCCR 1481, you're charged with the state jail felony offense of engaging in organized criminal activity from September 28th of 2025. And how do you plead to that charge?
Guilty, Your Honor.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes.
Do you fully understand that?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
State tenders number 1.
Objection, State.
It's admitted. Is there any evidence that Mr. Chandler is not competent?
Oh, yeah.
There's no prior criminal history, Your Honor.
There's not.
Not that I see.
I was just trying to look at what the
He and a group of friends were driving around shooting people, paintball guns.
handguns.
Your Honor.
So I want to get all those names. Let's see.
Got it.
I've got them right here.
Okay.
So any reason then not to waive the pre-sentence report?
Nothing, State Judge.
All right. Did I already tender? Did we already admit state tenders number 1?
Objection, State.
It's admitted. Is there any evidence that Mr. Chandler is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years.
Yes.
You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. That includes having absolutely no contact and no communication with Jason Weinberg, Aiden Dickinson, and Corbin Rayleigh.
Yes.
That obviously means in person you can't hang out with them, but that also means you can't Snapchat them, DM them, send messages, whatever it is. No contact, no communication. You understand? If you do everything that you're supposed to on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. You're young. Having a felony conviction would be a very negative thing for you and for anybody on their record. So if you successfully complete the probation, the case is actually dismissed at the end.
Yes, ma'am.
The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty, so you become a convicted felon and sent to the state jail prison for up to 2 years. Do you understand?
Yes, ma'am. Right.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork.
Yes, ma'am.
Good luck to you, sir. Thank you very much. Yes, sir. Thank you, Mr. Nichols. Davis?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She does.
Ms. Davis, in cause number 25 DCCR 1450, you're charged with the second-degree felony offense of assault on a peace officer, and that's from May 19th of 2025. And how do you plead to that charge?
Judge, it is a reduced charge.
Oh, I'm sorry.
Yes, Judge.
Y'all gotta
Sorry.
stop me before I get too far. Hold on a second. Let me withdraw everything I just said. So it's the class A, just a regular assault.
Resistance arrest.
All right. It's pulled up right now. All right. So Ms. Davis, in clause number again, 251450, the state's elected to proceed on the lesser included offense of a Class A misdemeanor resisting arrest. And that's for May 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 1-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes.
State finish number 1.
No objection, Judge.
It's admitted. Is there any evidence that Ms. Davis is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you have a conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed and you'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sent to the Jefferson County Jail for up to 1 year. Understand? All right, I've handed you the trial court certification that shows you've waived your right to appeal since I followed the agreement. You need to stop and talk to probation or have a seat in the courtroom until she's ready to call you up. She's at that desk right there. So just watch for her to call your name. She'll go over your paperwork with you. All right. Bless you, ma'am. Thank you.
Never seen that man so out of breath.
All right, sir. You Marshall Chance.
Yes.
And Mr. Chance is here in clause number 26, DCCR 0370, and charged with aggravated assault with a deadly weapon. Mr. Gertz is the attorney. Mr. Eckhart's here for Mr. Gertz today, and has filed a motion asking that I consider removing the GPS monitoring device because you're unable to get on the premises of work. Is that correct? There's an issue?
Yes, Judge. So since he's been on bond conditions, he's been on short-term leave. He is now in the process of trying to get back to work, and the facility will not let him work where he does, where his normal job duties require because he works around explosives. The GPS company, they've gone through efforts to see if the GPS company can verify the equipment as it's an industry term, intrinsically safe, meaning that it can withstand, any elements that would potentially cause, ignitable liquids to explode. So I think there's a lot of devices that cannot go into certain facilities because they are not deemed intrinsically safe, like cell phones and things like that. And the GPS monitoring company cannot verify that. So we're kind of at an impasse where he's either going to lose his job or we're going to have to figure out another way to monitor him.
All right. And just for the record, I am taking judicial notice of the court's file, review the probable cause affidavit as well, and that underlying offense. Mr. Smith, what's the state's position?
I don't, and I understand where they're coming from, and I guess I don't have much of a position. And Judge, just for the person to lose their job, right? Just for what's
Well, I mean, I would too. However, there's obviously the allegations are very serious. Has there been any issue that you know of? Have you heard from the complaining witness?
not that I've heard from, and not that I know of, Judge.
So here's what I want to do. I would like for you to get in touch with her prior to me ruling on this. And what I can do is we don't necessarily, if there's no issues with her and any contact, put it in an email between myself and you and Mr. Gertz, and I can make a ruling without having to come back to court. And I can do that a little quicker since we don't have a docket next Monday. If there is an issue, then obviously if we need to come back, we'll reset it, just for a couple of weeks and come back and, let everybody make that argument or bring her here or whatever we need to do. Okay? All right. So stay in touch with Mr. Gertz. He'll be getting an email and we'll, figure that out if there's any issues, and then I'll make a will for that. Okay?
Thank you, Judge.
Yes, sir. Looks like, okay, so you're John Martin.
Yes, ma'am.
It's Miss Malfino's. John
I
Martin.
recognize the name. Sorry. No.
Just 25 DCCR 0583. Mr. Martin's charged with injury to a child, elderly, or disabled. It looks like I have a notation that he was going to need to go get a 10 print done at the jail. Did you get that done?
What?
A what? A what? I don't know. I have a notation on my docket.
And be permit
Huh?
for the TRN with,
Did he bond out of another jail or something?
He hasn't even played this game.
No, it's not for a plea. It's because there was an issue, I guess, at the jail with
what's your middle name?
Ladies.
John Martin. Are you John Martin?
Yes, yes. Yes.
Right, in DPS, I don't know, something happened at the jail, it didn't happen right.
Okay.
To have an accurate TRN, it needs to be.
It's just he goes and he does it and he leaves. It's not going in.
You
Do
can,
they know that
he needs to speak with Latonia.
if you could? This is the first I've known about it, Judge.
Well, I don't understand. Okay, never mind. Maybe was just because that came up between, okay. So what we need you to do, it looks like, there was an issue when you were in jail getting the prints done right and the number assigned to your case through DPS. So I'm going to order you between now and that next court date to go to the jail. It's probably best if you go, not probably best, you need to go during working hours so that you can ask for that person. Miss Werner will make sure that she knows you're coming. It'd be great if you would go get it done today, possibly go straight there, get it over with so that we don't have any issues. We've got to get that done before we can do anything else. Okay.
Okay.
So you'll just go to,
Then let me know that you've done it. So
he needs to go to releases, I guess, and go in through that door. You'll go in through the releases door. You can explain where y'all go through, Mr. Burbank,
go to the window, say I need to see this.
to do it, just to do my fingerprints.
Where I came out of, the one next door.
Mm-hmm.
You know, where you came out of,
Where you came out.
go back in.
And there's a window right there.
Okay.
Where you came out, go into that door, go to that window and tell them that you have to go do your 10 print and ask for her and they'll know what you need to do. Okay. And they'll just get your fingerprints done and you'll be able to leave. Okay. Nobody's going to keep you there or anything.
Already. Okay.
Okay. So now, so what is the actual announcement though?
Yeah, we're something was to yes.
Got the records, Judge. They were not separated. They were redacted
Right.
and they were sent to me.
Right. You've sent them to
Unredacted
everybody.
and redacted.
Yeah.
At your instruction, I sent you the thumb drive with the originals. I did not open them and I provided Mr. Burbank myself a copy of the redacted.
Right.
And that's where we.
And I'm going through it right now, Judge.
Okay.
And so I just asked for.
So this will be the last reset. We waited a while on those. And so now that we have that, let's get done, reset it one more time. Let's get an announcement at the next court date. Make sure you go get those fingerprints done. Okay.
Okay.
All right. You're free to go, sir.
So,
And then you have Crystal Robertson.
yeah, sure.
Okay. Thank you. Good morning, ma'am. Are you Crystal Robertson?
Yes, ma'am.
This is 25 DCCR 1526. Ms. Robertson's charged with forgery of a governmental instrument. And what is the announcement?
That's for one more reset, Judge. This is a restitution case. Unbeknownst to me, she's paying restitution to the bank right now.
Okay.
And so it's just a money thing.
Figuring out how, okay.
And so, and then it's all will be,
All right. We'll just do a normal reset. And then we'll see where we are at that.
and she is making payments to get this matter taken.
Okay.
But it's also trying to get money to get it over.
Okay. Sounds good. Stay in touch with Mr. Burbank. He'll let you know when your next court date is. You're free to go. And then I'm holding, Chandler. Did
Yeah.
we end up taking care of? Good morning, sir. Are you Richard Couch? Speak up, please. And will your client waive the formal reading of the indictment?
Yes, Your Honor. Sorry about the fold.
That's okay. see, Mr. Couch, in cause number 26, DCCR 0142, you're charged with a third-degree felony offense of driving while intoxicated with previous convictions from December 8th of 2025. The indictment alleges you were previously convicted of driving while intoxicated December 2nd of 2013, and after that was final, you were convicted of driving while intoxicated March 22nd of 2018. And how do you plead to that charge?
Guilty.
And are those prior DWI convictions true?
Yes.
I have here are you pleading guilty and true freely and voluntarily?
Yes.
And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like you guys have agreed to at least underlying a 10-year term in prison that would be probated. There would be a $1,500 fine, the required 10 days in jail and other conditions. But as far as the length of probation, you're leaving that up to the court. You're asking for 5 years. You're asking for 10 years. Is that what you understand as the agreement?
There is, as part of those standard DWI terms and conditions for a third ignition. Yeah.
Right. Everything that would be a regular condition as well. So really the only thing that's not agreed upon is the length of the probation, correct?
Right.
All right. Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenors number 1.
No objection.
It's admitted. Is there any evidence that Mr. Couch is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, we'll see you back at sentencing. Thank you.
Thank you, Your Honor. Be excused.
Yes, sir.
And just like that, the courtroom clears out, but the consequences are only beginning. Some defendants walked away with probation and a second chance, others left with their future hanging by a thread. One wrong move from here and everything changes. Which case shocked you the most? Let me know in the comments, and don't forget to like, subscribe, and stay tuned for more real courtroom drama and legal breakdowns.